Imagine being an employee in China, working hard for your company, only to find out that your rights have been compromised due to a lack of social insurance coverage. This is a harsh reality that many workers in China face, but the tide is about to turn. The Supreme People's Court in China has recently issued a judicial interpretation, dubbed the New Social Insurance Rule, which is set to take effect on September 1st, 2025. This landmark ruling aims to unify adjudication standards for labor disputes, providing more protection for workers' rights and imposing stricter compliance requirements on employers. But here's where it gets interesting. The interpretation has sparked a heated debate among netizens in China, with many believing it makes social insurance universally mandatory, which could increase operational pressure on small and medium-sized enterprises. However, experts like Song Puen, a Shanghai-based senior partner, argue that this interpretation does not establish a universal mandatory social insurance system, but rather clarifies the invalidity of waiving social insurance to regulate enterprises' employment and social insurance contributions. So what does this mean for workers and companies in China? For starters, any agreement in which an employee voluntarily waives social insurance is now considered invalid, giving employees the right to terminate their labor contract and seek compensation. Employers who have repaid their overdue social insurance contributions can recover substitutes, such as cash incentives, that they had given to employees as a replacement for the social insurance contributions. But, and this is the part most people miss, companies must rectify any omissions promptly to reduce the risk of contract terminations. The new judicial interpretation also sheds light on non-compete restrictions and other aspects of labor contracts. For instance, the scope of non-compete clauses for an employee must align with the scope of trade secrets they can access. If an employee has no access to trade secrets, the relevant agreement may be deemed invalid. Experts suggest that employers should implement a tiered classification system for non-compete agreements, customizing agreements according to the level of confidentiality each position might access. This raises an important question. Should companies prioritize protecting their trade secrets over employee rights? The judicial interpretation also addresses the legal issues arising from employees being required to work for multiple affiliated branches of the same parent company. If an employee is alternately or simultaneously used by multiple affiliated companies without a written labor contract, the court will determine the employment relationship based on actual job practices, including work arrangements and working hours. This has significant implications for companies with complex corporate structures. Furthermore, the construction industry has been put on notice, with Article 1 of the new judicial interpretation addressing the responsibility of the actual contractor in cases of illegal subcontracting. Companies that subcontract business to unqualified entities may be held directly liable for labor remuneration, work injury benefits, and other liabilities. So, what can companies do to avoid these pitfalls? Experts recommend that employers rigorously vet the qualifications of subcontractors and affiliated entities, clearly define the allocation of rights and obligations in contracts, and specify compensation for breach of contract in their agreements. As the new social insurance rule comes into effect, it's clear that the landscape of labor disputes in China is about to undergo a significant shift. But we have to ask, will this interpretation be enough to protect workers' rights? Or will it create undue burden on small and medium-sized enterprises? We'd love to hear your thoughts. Do you think the new social insurance rule is a step in the right direction? Or does it need further refinement?